I'm very happy to host Peter Baldwin. He will introduce himself a little bit more in a minute, but let me first set the scene and say why I'm happy, because what we are going to talk about today is the future of the public domain, the future of the public domain of publicly accessible, usable knowledge, about the future of our cultural heritage that we use also to create any form of new knowledge, of new cultural artifacts. And I think one of the best ways to theorize what the future of the public domain might bring is to look back at the history of the public domain, at the history of copyright laws that govern, restrict, or even create the public domain. We can debate that. And Peter Baldwin is an historian who has not just written a book on the copyright wars, looking back in the history of the development of copyright laws and the public domain, comparing European copyright, Urheberrecht, authors' rights, and US copyright law. But his most recent book, Athena Unbound, Why and How Scholarly Knowledge Should Be Free for All, really taps into what more recent changes, also in terms of technological changes, might bring. And actually, if we look back at this, the last thing that I would want to say here in the beginning is, if we look back in the history of copyright, we can observe that every time when there were fundamental technological changes, copyright changed as well. Yeah, and so the last big change was inspired to some degree by the digital revolution, by the internet. And now what we are witnessing is the AI, LLM, whatever, revolution, which has again fundamental consequences for how we perceive authorship, what copyright regulates and doesn't regulate. And so, Peter, I'm very curious to hear about your historical perspective on the future of copyright and the public domain in the age of AI. And to start, maybe give us some hints how you actually ended up researching and theorizing around this topic.
Is this working? Good. Thank you very much, Leonhard. I'm flattered to be here, honored to be in a place with so many people. Had I known this conference or this affair was so big, I would have been even more nervous than I already am. But it's gargantuan what you have here, and a fireside chat in a digital IP kind of festival here. It's such an analog concept. It's a bit like, sort of roasting marshmallows on a space flight or something like that. It doesn't quite fit together, not to mention the tragic lack of a fireplace, but that we'll look at, sort of ignore that. Anyway, let me just say a word or two how my journey to open access, as it were. 20 years ago, my wife, Lisbeth Relsing, and I started the Arcadia Fund, and one of the things that we do is open access. We came to open access because we were appalled by the way that academic knowledge is locked up behind paywalls, even though taxpayers have paid for the vast bulk of it. Both of us are trained historians. Both of us have worked in universities for much of our lives as faculty and researchers. And England has a long tradition of what we used to call gentlemen scholars, but nowadays I guess would call sort of amateurs. Serious people writing serious books on serious topics. And when we would go to them and say, so how do you manage to get into JSTOR to read the articles that you need to write about, Churchill's wartime policies or whatever? And they would say, what's JSTOR? And so not only did they not get into it, they didn't even know that it was there to get into, as it were. And of course, this merely highlighted the grotesque disparity that exists not only between the university world and anyone else who wants to read the output of what academics produce in the first world, but between the first and the rest of the world, and the north-south divide in terms of this sort of material. So we have, we are something like the third or fourth largest foundation in the UK. We give away about 100 million a year. 20% of that goes to open access, which I think makes us one of the bigger funders in the field. One of the projects that I'm most pleased and interested and excited by is a very large, sort of 50 million over 20 years kind of project that we're doing with the New York Public Library, that will effectively attempt to make all in copyright but out of print books available on screen, no fear of downloading to aggravate the rights holders, to anyone anywhere in the world, and trying to set an example for what a research library with a public mandate should be doing. And then, as you mentioned, I've read this book, which of course is downloadable directly from MIT Press on the website, or I think there's a link somewhere yes, right. So, enough about me. Let's talk about you. What do you think about me?
No. No. Of course, we discussed in advance, and I think what struck me actually in your analysis of the state of the public domain currently and maybe in the future was how you, on the one hand, actually painted a dystopian future where actually we task private for-profit publishers with preserving actually our cultural heritage, which they are neither equipped nor willing to do. And together with, they might change things, they might, they have restrictive licensing schemes, they don't even grant access to certain versions, so making it harder for libraries to do their job, what you just described for the New York Public Library. But at the same time, you also sketch a future, maybe a little more distant future, where actually given, or if we assume that copyright terms are not further extended, that actually the number of works that are available in the public domain, free to use, will grow and grow and grow, so that I would say a utopia of a public domain dominated culture where we can actually, to quote Wikimedia, we all share in the sum of all knowledge, or at least most, or close to the sum of all knowledge, that this is also on the horizon, at least. Yeah? And my question to you now would be, is it, what do you expect we will really experience? Where will we end up? Yeah? And will actually copyright and IP industries, intellectual property rights holders, will they allow such a public domain dominated culture to emerge even?
Well, can I set this a bit in context first? Because my title was, I think, something like the paradox of the public domain thing. So, why a paradox? It seems to me that there are sort of two entirely, almost diametrically opposed things going on at the moment. And one has to do with the way in which it's unclear to me how we even will have a legally enforceable public domain for digital content. And the way this works is that with analog content, let's just stick with books to make things simpler. I'm going to stick with books throughout this, I think, just for simplicity's sake.
Still a historian.
And as a stick-in-the-mud historian, exactly. The way it works with analog content, of course, is, it's a bit like any other ownership. You have the right to do what you want. You read the book, you can sell it, you can lend it. You have to wait until the public domain kicks in, 70 years plus the life of the author, until you can do things like translate or republish it or all that sort of stuff. But basically, you can do with it largely what you want. But for digital content, of course, things are very different. You don't actually own physical books, you lease them. And as consumers, we've had that experience, not necessarily personally, but we know of people who have had books on their readers, whatever they may be, that are either removed because of some copyright dispute or are edited because of some offensive language that someone has. So it's an unstable medium. You don't actually sort of have it, you don't own it in the sort of way we do with physical material. Now, that's bad for consumers, but for research libraries and libraries in general, it's even worse because libraries are supposed to preserve our cultural canon, but they don't do that with digital books at all. They don't own them, they don't store them, they don't curate them. They just simply lease them from the publishers or the middlemen between the publishers, the distributors, and they sort of have them for a certain amount of time. And there's a certain logic, I suppose, in that for the latest literary fashion, which goes untrendy after a year or so. It might actually make sense for a library to pay a smaller fee to a publisher to have a file on tap for a year and then not have to pay for it after that. But for research libraries are supposed to curate and preserve our cultural canon, this is sort of a little short of a disaster, because the research libraries simply do not have the material in their stacks, on their shelves, on their servers. It's not theirs. They are simply the funnel of money from whoever the funder of the research library is to the owner of the rights, and hoping to allow the intermediaries, the consumers, to sort of read the books for a while. So the question is, when you have a digital book on your that you've leased as a research library, what happens when the public domain happens 100 or so years from now? Who's to say that the publisher hasn't changed it somehow? And if the publisher has, does that mean that another copyright has been taken out and that this particular version is maybe in the public domain but another one isn't? And in any case, these files are on the publisher's servers. Who is to say that the publisher is going to release them? Who is to say that the publisher even knows where they are? Who's to say that the publisher is willing to keep these things on their servers in perpetuity, even though they're not making any money off of them? I don't think you have to be a hard-bitten cynic who's been scarred by life to think that there's maybe not a happy ending here. And so it's unclear to me how we actually have a sort of legally enforceable public domain in the digital age. At the very least, you would need some sort of deposit requirement whereby whatever the national library is gets to receive digital copies of all files. That is the case in some countries, such as Germany. It is not the case in others. In the US, there is no digital deposit requirement, and indeed the physical book deposit requirement is at the moment up for grabs because a court case recently declared that to be unconstitutional, and I'm sure it's going to be appealed, but who knows what's going to come out of that. So, on the one hand, and this is the first leg of the paradox, we have this question of, is there a legally enforceable public domain for digital content? Then, if we turn the question around the other way, and we look at what the public domain will mean in the future, if again we stick with books, we try to quantify these things, something on the order of 20% of all content at the moment is public domain, so a minority of it. That is the case at the moment, but in the future, the long distant future, whether it's 100 years or whether it's 1,000 years, that's no longer going to be the case. The public domain will be the vast majority of all content. In effect, you could say everything that's worth saying has already been said in one form or another. And the question is, how is this going to affect, on the one hand, creativity, but on the other hand, how is this going to affect copyright? Because what really is the point of copyrighting that little fringe of new material when you've got 99+% of everything that already is in the public domain? The interesting thing about AI and large language models is that they effectively bring forward the day when we're going to face this problem, possibly to sometime much sooner in our own lifetimes, conceivably, because if they now start spewing out vast quantities of content that cannot be copyrighted because it's not produced by a human, then in effect we will soon have the majority of all content in the public domain and only a small smidgen of content in copyright. And then again, the question is, what's the point of copyright in that sort of future? So here the paradox is, on the one hand, we don't really know whether we have copyright. On the other hand, copyright may not mean anything fairly soon.
But now let me get to my initial starting point as a historian. If you look back in the history of copyright, and if we take this, what has happened in the past, as some guide to predict what will happen given this actually contestations that we are already in the middle of, New York Times suing OpenAI and that kind of stuff, So wouldn't it be safe to predict that actually in the past we've seen new technologies and the invention of new rights? So for me, in my, the first time I really got into copyright activism, it was of course the invention of copy protection measures, and then inventing a law that in a way punishes the circumvention of copy protection measures to allow copy protection measures to be effective in the first place. And actually, when we look at AI right now, they're also facing boundaries that actually are sometimes, or maybe to an increasing degree, drawn by these copy protection measures. And wouldn't you expect also new laws and you know, even further, farther-reaching copyrights to be invented in response to what you just described. That, from the rights holders, publishers' perspective, the danger of this huge public domain that we could all draw from.
So you're asking, if I've understood you correctly, effectively the IP industries are going to sort of do another stitch-up and extend their powers even further.
Isn't this what history has taught us?
The book that you kindly alluded to, The Copyright Wars, is in effect the story of that happening over and over again. There's certainly no denying that the IP industries are enormously powerful and that they have expanded time and time again their powers. You know, in 1710, when the Statute of Anne was passed, the first copyright law anywhere in the world, in the UK, very little stuff was in copyright, of course, because they were only starting to invent the intellectual property. Of course, at the same time, they invented the public domain, but almost nothing everything was in it, very little in copyright. And then, of course, in the interim 3 centuries, we had an enormous revolution in publishing techniques and vast quantities of published material. That means that now we're sort of in a reverse situation where the majority of all content is copyrighted. And then the question is, in the far future, we know for a fact that that will reverse again. And the question is whether the LLMs bring that forward. But the point is, what you're asking is, clearly the copyright industries have been expanding their power. They've gotten ever longer durations for copyright. They've managed to get rid of the formalities required to put things in copyright. They've expanded copyright to ever newer forms of content, and so forth and so forth. So the real question is, are the IP industries invincible? And they're, having spent a lot of time and writing, sort of pointing out how they were not, I'm willing to entertain the possibility that there are ways in which, and times at when, the IP industries have their tails clipped. So compulsory licensing, for example, was in effect the act of throwing the sheet music industry, which once was the only way of conveying music, under the bus, thanks to the interests of the recording industries. I mean, player pianos and what developed out of that. So one industry fighting another, where one industry got a big advantage at the expense of another. The safe harbors provisions in the American copyright legislation is in effect a way of letting certain industries put up material that they don't have to be responsible for, and allows things like YouTube to be possible in a legal sense. And so has, again, been a decision against certain industries, the IP industries, in favor of other industries. And fair use, in the broadest sense of the word, is, of course, also, I mean, really a taking of material from the IP industries and giving it to other industries. So it's unclear to me that kind of battle won't happen again. And in fact, it seems to be that's what we're seeing as we speak. The New York Times suing OpenAI. There's a huge battle between the copyright industries and the industries, the LLM industry, if we want to call it that.
But when we both of us academics, and I guess I see a lot of people in the room, are neither. Yeah? They are neither OpenAI or LLM industries, and they are also not rights holders. Some of you are probably authors, but I guess very few of you can live from your royalties, which is a very safe bet because hardly anyone can. But then the question is for us in the room now. Is it clear who to side with in this war? Is it having experienced the past? So should we now, in a way, side with OpenAI?
You want to pick your culprit here, but look. If we think about it from the point of view of society as a whole, we all want LLMs to be as good as they can be. We don't want LLMs feasting only on sort of the garbage end of the internet. So in a sense, open access is crucial to having good LLMs, right? We want them to read the currently paywalled academic data on the internet and be as good as they are. No doubt they want to be as good as they are too. So the question is, for training purposes, is there any reason why the LLMs should not contribute to what it costs to create high quality content? In a sense, all of us, when we're trained, somebody pays for the books that we read during our educations, whether it's the school system or the libraries or our parents or whatever. Somebody pays for the content that turns us into educated human beings. Then the question is, once they've been trained, what they do then is, should that also be something that they, in a sense, pay for? And there, I'm more hesitant, because I don't really see that what the LLMs do is significantly different from what humans do. I mean, humans scrape the web too. We just do it on a smaller scale. And when we make up our content out of the massive content that others have created before us, we don't necessarily feel obliged to pay royalties to them, or we acknowledge them as a sort of moral duty. And of course, the LLM should do that too. But is that something where there needs to be an economic transaction?
So would you feel misrepresented if I summarized your answer as yes?
I've forgotten the question by now. So I
yes,
don't know
yes, we should side with OpenAI.
Right, yes. Well, yes, fundamentally, LLMs seem to be a good thing, and we want them to be as well-functioning as possible.
But then, maybe to turn to the first part of the copyright paradox, or the public domain paradox that you introduced before, isn't then maybe one of the bigger problems that actually, you mentioned the importance of fair use in the US or copyright exceptions in Europe for actually some of the most used services on the internet. You mentioned YouTube. I would add TikTok. I would add all of those remix culture platforms out there of user-generated content more broadly, which actually are carved out of the copyright exemptions that there are, or Google Books, to give another example, that's based on fair use. But then, at least particularly in Europe, we face the problem and the challenge that actually a lot of these fair use or copyright exceptions, they are defenses. So they are not, you cannot kind of circumvent copy protection measures and justify that by fair use. Yeah? So would you see then OpenAI and also the industry, the AI industry, as an ally in this battle of strengthening these exceptions?
Well, at the moment, yes, they certainly could be that. Look, the LLMs face two court battles at the moment. They want two almost entirely different things, right? On the one hand, they would like their output to be copyrighted, otherwise it's worthless. On the other hand, they want fair use exception for their use of other people's content. So these two court cases, we have no idea how they're going to go. They could go both in the direction of favoring the LLMs or in the direction of slapping them down. In either case, there are very powerful people on either side of this issue, and not everybody's going to be happy at the end.
But isn't the biggest danger then, when I listen to you, that actually those, that they agree on something at the cost of all of us? At the cost of maybe the public domain? That actually there will be an agreement met? Actually, that was also part of what some people feared in the Google Book settlement. The Google Book settlement, for those of you who have not followed it, in the end there were court cases trying to outlaw Google Books, Google Book search. And in the end, and first there was a Google Book settlement that actually was kind of an agreement between Google and rights holders. And actually some argued that it was an agreement actually paid for by the public, by third parties. And in the end, the settlement was invalidated, and then there was a final decision that ruled that Google Books is fair use. I simplified, but I would say that's more or less the story. Wouldn't you see that then maybe even a bigger danger is that we have an AI settlement, yeah, where actually OpenAI and the copyright industries agree that kind of in revenue sharing and creating a huge new monopoly that we all have to pay for then?
Well, it's even worse than that. There is a very bad possible outcome. There's no question about that. That AI gets a fair use exception for itself and it gets to copyright its output. That would be dreadful. Okay. But there's also a very good outcome, which is the converse.
But then, given what you said, then this again brings me, I know I simplified a little bit when I said, should we side with OpenAI? But then I would say, who are then, this is a danger, this is a real danger, you know, using the fair use exception for LLMs, but then creating a huge body of copyrighted material. Then who are the ones that we should side with?
When you put it that way, of course, I find myself strangely rooting for the IP industries, yes. So,
No, I would say in the end we should side with the libraries because in the end they are the ones that really have this public mission, and they are always at the. Actually, they are often in between the old old chairs. Can we say this in English?
They fall between the stools.
They fall between the front lines of the industries because they are not an industry on their own, and of course they don't have the lobbyists and that advocate for either of those two positions.
No, I worry immensely about the libraries in the digital age because it's totally unclear to me what their role actually is going to be and whether there really is a serious role for them other than a kind of, glorified internet cafe where people go and read on screens and occasionally log in to download a book to read, that sort of thing. It's
But then, and this brings me, we are actually approaching the end of our fireside chat, but one question that I wanted to end up with, and I think we arrived at this point that I need you to ask that, because one of the most prominent copyright critics of our lifetime was, of course, Lawrence Lessig, founder of Creative Commons, then Stanford, now Harvard law professor. And actually, after about 10 to 15 years of copyright scholarship and activism, he left this field behind and turned towards money in politics. And actually is now doing research on how money corrupts politics. He had a once short-lived presidential run of his own. And what he argued was that if it's not possible, to win such a clear-cut case as the copyright case that he advocated for in favor of the public domain, and that was actually won by the special interests, Disney and others. Isn't then the problem also here, in this case, the corporate interests? Shouldn't we all leave copyright advocacy behind and also follow Lessig in his battle against corporate interests in politics and beyond?
Yes. Well, it's funny about Lessig. 20 years ago, my sort of introduction to this whole topic was I was recruited to be the respondent to a talk that he gave here in Berlin. And 20 years ago, I was just completely winging it. And if I now was back in that situation, I could probably do a slightly better job out of it than I did back then. But as you say, he's gone on to other things, but the thread that's common to all of them is the corporate interests. And that is, of course, true. That clearly corporate interests are enormously heavy hitters in all this. My hope is, as I think I've already tried to allude to, is that corporate interests are not monolithic, and they often battle each other. And we saw this in the early 2000s when effectively the content industries battled the device and software industries, Southern California versus Northern California, and that battle is what got us the safe harbors and various other things that have sort of leavened the IP industry's stranglehold of this. And I'm hoping that the LLMs fighting the intellectual property industry, that there will be a sort of similar outcome where something good for the public and the libraries will come out of this in the end, and it won't just be some corporate monolith. But certainly Larry Lessig's warning should be taken very seriously.
So we've reached the end, but we will both stick around a bit. So if we only had a half an hour for this chat, so I can just invite you to approach us after this talk if you have additional questions. But I like where we ended up with that. Actually, this conflict between the industries is actually, it might end up and we all might end up with egg in all our faces when they find together, and actually the public will pay the price. But maybe there's something to be won here if we drag out their battle a bit and we end up with a solution that actually strengthens the public domain, an AI-powered public domain, if I summarize it correctly.
Yes, I would agree with that.
Okay, so then thank you for your attention.